Welcome, everyone. Today we have a very interesting topic. It's talking about creditors' position, David.
That's right, Francis. So today we're going to talk about the position of creditors in an insolvent company. We'll look at the asset protection regime, position of certain creditors, as well as the process for proofs of debt, and then the priorities of payment in a liquidation.
Okay. Welcome to this YouTube channel of K-Leaders. I'm Francis Chan.
I'm David Wong.
David, please share with us your interesting topic.
Thank you, Francis. So today we're going to look at a company that's gone from financial distress into insolvency. As we've mentioned in previous videos, there are three types of winding up in Hong Kong. A member's voluntary winding up, which is generally solvent, a creditor's voluntary winding up, and a compulsory winding up, which are both types of insolvent liquidations, and that's the one we're going to focus on today.
Okay.
So when a winding up commences, in the compulsory winding up, that's when the petition is presented to the court, an asset protection regime kicks in. And what that means is that any sale or transfer of a company's property is automatically void. Similarly, any transfer of shares or alterations in the status of the company is also void. And this is all designed to preserve the assets of the companies for creditors between the commencement of the winding up and the actual liquidation process itself. Keep in mind, however, there is no automatic stay on proceedings at the commencement of a winding up in Hong Kong, but you can apply to a court to stop any pending actions. There is, however, a stay on court proceedings once the winding up order has been made.
I see. David, I think the major creditors is normally the landlords, and they do mount a lot of claims about compensation up to lease expiry and the reinstatement of premises.
That's right, Francis. In any liquidation in Hong Kong, a landlord is going to be a major creditor. But of course, landlords have something called an action for distress, which is where they can go in and seize the property of the tenant in order to pay unpaid rent. Keep in mind, however, that any action for distress must be completed prior to the commencement of the winding up in Hong Kong. Otherwise, it's void. This is a similar position for other judgment creditors. So if you're a creditor with a judgment against a company, execution of that judgment must be completed prior to the commencement of the winding up. Otherwise, the creditor is not entitled to retain the proceeds. It's the same for any other attachment, sequestration, execution, or distress. They're all void if they're not completed by the commencement of the winding up.
Wow, it's so important.
It is very important. So we can now have a look at the process of the winding up. First thing to keep in mind, of course, is that secured creditors stand outside of the process we're about to talk about. This means creditors can enforce their security directly for their debts. For other creditors and contributories, however, they will be given a notice to attend either a meeting of the creditors if they're a creditor, or a meeting of shareholders if they're a contributory. At the meeting of the creditors will be required to submit a proof of debt for voting, and then the liquidator will explain the situation of the company and the process from there. Creditors can also appoint a committee of inspection, and that is something to help the liquidator in the liquidation process.
David, here I want to ask a question. Yeah, I think for insolvent liquidation, if the company do not have any assets but just liabilities, are the liquidators still required to adjudicate claims?
Yes, they are, Francis. So they must complete the liquidation process. And in fact, most of these insolvencies will mean that there are less assets than there are claims.
Okay, so in revenue, the tax liabilities.
Well, that's right. So if there are unpaid tax liabilities, then the Inland Revenue Department will be a creditor in the insolvency process. But as we'll see, they have a slightly different position.
I see.
So the liquidator will then proceed to bring in the assets and pay the claims. And for compulsory winding up, this will be done under court supervision.
I see.
Now, as I mentioned, the starting position for creditors in a liquidation is pari passu, which is a Latin phrase meaning equality. All creditors should be treated equally.
Okay.
In substance, however, certain claims are paid in priority to others. The first of these will be the expenses of the winding up, including the liquidator's remuneration. And then the second priority is for what are called preferential debts. And these include, for instance, debts owing to the government, such as unpaid taxes, and employees.
Okay.
And after all those claims have been paid in full, then the rest of the company's general creditors' claims will be paid, including any outstanding interest. Finally, if there is a surplus of assets after that, then they will be paid to the shareholders. Of course, in an insolvent liquidation, generally the shareholders will be left with nothing.
I see. So I think the employees will be very much anxious to know their rights. Can you tell more about this?
Sure. So as I mentioned, employees are a preferred creditor, at least in part of their claim, which means that their claims will be paid in priority to the general creditors.
Okay.
Something else that employees should know is that the government has set up the Protection of Wages on Insolvency Fund. And what that does is it pays the claim in priority prior to the actual liquidator doing it. So employees can apply to the Labor Department and the Labor Department will process that claim and then make the claim for the unpaid wages on an ex gratia basis. The Protection of Wages on Insolvency Fund then kind of steps into the shoes of the employees for the rest of the insolvency process. There are, however, limits on how much of each employee's claim is paid for their entitlements, which means that the creditor will remain a creditor for the rest of the part of their claim which the Protection of Wages on Insolvency Fund hasn't paid.
Okay.
And of course, finally, any fees or wages owing to directors are excluded from the Protection of Wages on Insolvency Fund.
I see. So Derek, how quickly the employees can get payment out of the funds?
Generally, it's very quick. So you can apply on the presentation of the petition and in a matter of weeks, if the claim is approved, the Labor Department will make the payments.
That's great. It's so important to get the fund very quickly.
That's right. That's right.
Okay, so thank you very much for your presentation today. What should we take away after this episode?
Now, as always, I think it's important people realize that they should act early when dealing with companies in financial distress and seek professional advice. They should also not ignore any notice if they receive one of company going into liquidation, which means attending the meetings and then filing a proof of debt as well.
Understand. I think if creditors cannot really attend those meetings, they can still have the right to ask the liquidator for a copy of the report of the meeting, right?
That's right, but as long as they file a proof first.
Okay, understand. So thank you very much for the sharing, David. What will you cover next time?
So next time we're going to look at the position of debtors and other counterparties in the liquidation process.
Oh, excellent. So stay with us and see you next time. Thank
Bye.
you. Bye-bye. Thank you for watching this video. If you like it, please give us a like and subscribe and share with your friends. Look forward to your continued support. See you next time. Bye-bye.